I have spent all these years with Joe Lieberman eating salmon, riding the Shabbat elevator, not being able to ride in a car on Saturday. I've had to go through all this all these years, and I've gotten none of the benefits, so I'm announcing my conversion to Judaism. And Joe said,
things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you. That was...
Welcome, everybody. This is Tyler Yonke, LPR. Hope you're having a good Sunday. Just got a few issues with the chat showing up on my system, as always, from YouTube. I don't know what's going on, but we're gonna see if we can make it work out. And then we're going to walk through this thing. You just saw a McCain little montage there talking about changing to Judaism. I don't know what's going on with that. But here we are. I am not inebriated at all. I've got water, matter of fact. There you go. Let's see if I can even, let's see if people are even in the chat here. I don't know. It doesn't matter. This is mostly a recording for me, starting off today. There's been some, I don't know about consternation, but there's been tweets out there talking about some legal issues that are coming about. And Jose said, Tyler, why don't you take a look at this? I did take a look at it. And it's this bill called HR 867. Okay. Now, some of these there's some really good stuff in here, and I'm sorry. But I'm going to go through most of the legal things. Let's just go here, see if I could, hopefully X works. Let's see, sometimes I got to reschedule it. Okay, here we go. So this person's saying, let's start with Laura Friedman. Love it or hate it, on Monday, the House will vote on HR 1867. Actually, I think it's just 867. The IGO Boycott Act, the current iteration of the Israel Anti-Boycott Act, to impose harsh penalties, including fines, jail, on Americans who, in line with their values, political views, boycott Israel and or settlements. I think I'm going to read through this person's kind of their breakdown of this. Hang on just one second. I don't think I'll be able to do that. So if I may not get to your messages here today, just throwing this out there. But go ahead and super chat, Rumble rant, do whatever you want to do out there. I appreciate it. By the way, I watched a thing this morning, more Barnes and Free, Viva. I mean, it was actually stuff they'd done, but then it's Nick admitting to things, and maybe we'll get to that next week. Okay. As covered on February edition of the Roundup, she keeps going 1867, but it's 867. Like its predecessors, seek to amend, expand current U.S. anti-boycott law. That law is based on the idea of preventing U.S. citizens from being compelled or coerced into boycotting Israel. Not quite compelled to do so. It's actually compelling them not to. Okay. As condition for doing business abroad under the Arab League boycott of Israel, which included coercive. Okay, so she's just kind of shotgunning everything here. This bill, like its predecessors, seeks to extend this law to, quote, cover U.S. citizens who boycott Israel and or settlements, not because they are being compelled to coerce, but because it reflects on their own values, political views, including, not quite right. With the hookup being the EU's policy urging companies to differentiate between Israel and settlements, the UN's database of companies working. Okay, I don't really know what she's doing here. I'm going to actually back off on this because what I want to actually look at, this person here then says the bill number is HR 867. There you go. Our country's founders are rolling in their graves. Ban free speech, criticism of a foreign country in America. Any member of Congress who votes yes on this bill is willing to sell Americans' constitutional rights for the interests of a foreign nation. What do you call that again? Now, look, I am just going to say this right out front and right up front that I do not believe, I'm not a fan of this, okay? And by the way, you know, if you want to, you know, the BDS movement or whatever it is there with Israel, fine. I have no problem with that at all. Hang on, I'm gonna move this chat over here so I can at least see what's going up. We will just put this, I'm gonna put this right over here so I can at least see what the chat is doing. Like I said, I may not, let's see if I could do this part. Hang on with me, folks. We're gonna try to add this in here, see if I could at least have this. Oops, sorry. Just bear with me. Talk amongst yourselves. I don't know if I'm gonna end up moving this out at all, but full chat. Let's try this. Let us try. Sorry, hang on. Nope, that's not working. Why is this not giving me a chance to do this? These are things that some of it is the way that this OBS is, that when I do a, there you go, maybe that'll work. There you go. When I do a go live on this, the way I have to kind of review it, anyway, let's try this. There we go. So we got your chats at least displayed out here. You guys can talk. Don't let LPR boycott who he wants, oy vey. Okay, so look, I'm just giving you first of all, and I've talked about this with the IHRA, the speech code and all that stuff. All of that being said, I want you to understand the practicality, okay? We're gonna walk through some of this, the legality and how this, is this even legal? Because people are like, First Amendment and all this. Okay, but does Congress have the ability? Do they have the right? What is gonna happen if this goes to, goes before the court, the Supreme Court or whatnot? Or what do they have jurisdiction to, the court has jurisdiction. Does Congress have the power and the ability under the Constitution to impose these kind of laws? And there's a lot of things that they could do that they put out there that I think is just outright unconstitutional. And, you hope that those get shut down. I think the IHRA stuff, the speech, is much more of a problem legally than this stuff is actually, okay? And we'll walk through why, okay? So now, the first thing you want to understand is, these two people here are rightly pointing out, Nearment said, I just read it. It has to do with employment. I'd like you to walk through it. Right. Well, kind of. So what I'm going to play this one more time because it's kind of an important part, which is how did we get into this?
I have spent all these years with Joe Lieberman eating salmon, riding the Shabbat elevator, not being able to ride in a car on Saturday. I've had to go through all this all these years, and I've gotten none of the benefits, so I'm announcing my conversion to Judaism. And Joe said, that was great, only I had to have a bris.
Okay, yeah, he's real funny. Okay, so why did I play McCain? Well, because McCain, this is it's an extension from two different laws, okay? So we will walk through those. Let's see if I can actually get them here. Because the first one is this what is this HR 867? Let's go through that first. We'll go through that, and then we will talk about what it is doing. So, because it's a little bit confusing, which is, here's the bill. It's brought by this Representative Lawler, okay? And I'm gonna throw this up here on my thumbnail. Let's see, is that the one? Yeah. So he's over there on the left. He is, he pushes these insane things all the time, okay? These insane things like speech codes and stuff if you talk about Israel. So he's the one that's bringing this. And this is a really simple bill to go through. The act is cited as the IGO Anti-Boycott Act. What is IGO? Okay, we'll get to that in a tad bit. Okay, so what are they going to do? It's just going to amend a 2018 Anti-Boycott Act. Okay, now there's a case, some case law, and I think an original law from 1979, which this kind of piggybacks on, and so it really has to do with foreign trade. Okay, so we're talking about that. Now, first thing is Tower Gang going to be taken on for being able to, or if you are out there on Twitter, talking about, or you decide you don't want to buy something from the state of Israel, are you going to be in trouble? No, you're not going to be in trouble. You're still going to be able to, there's other issues you're going to have. You're still going to be able to speak out against the state of Israel. Okay, this law is not going to affect that in the least, but it's a, we're going to talk about slippery slopes all the time. This has a lot to do with that. Okay, so it's an amendment of this 50 USC 4041 by inserting, quote, international governmental organization after, quote, foreign country, each place it appears. You're just going to do copy and paste, boom, boom, boom. You're going to add intergovernmental organization. So there's a foreign country that's listed in the code. We'll look at what that is. Every time it's in there, we're just replacing or adding IGO, International Governmental Organization, after the word foreign country. Okay, and then inserting International Governmental Organization after boycotting country, and or subdivision D, the first sentence by inserting International Government Organization after boycotting country. Okay, so as you can tell, it's just a lot of this same amendment stuff. It's really short. In section 1773, section A, 50 USC 4842A, by adding at the end the following. Annual report. The president shall submit to Congress and make available to the public on an annual basis a report that contains a list of those foreign countries and international organizations that foster or impose boycotts and with respect to which this section applies, and B, a description of those boycotts. Okay, so right there's an existing or a law already in place. So I just want to reiterate all this stuff. I appreciate the freak out. Okay, I appreciate the freak out online. The world is ending on Monday if this passes. First of all, this is Congress, Senate. We have a whole way how a bill becomes a law. That's what we're looking at here. So it's not going to happen on Monday. But is all shit going to hit the fan if it goes through on Monday? No, we're not going to. Why? Because there's already an existing law. This is adding one more element. Now, is this element going to be, Chesterton's fence? I mentioned that on Friday. I didn't remember. It was Chesterton. It is. Whereas, why is this fence here? Let's remove it. Let's get, there's consequences to things we do. Andy's in the chat and says, I love when Tyler reads fine print. I don't know. Maybe it's look, I have glasses. Okay. Which I don't need because I don't need stuff to read unless I wear my contacts. And then if I wear my contacts, then I have reading glasses. So there you go. So none of those work. None of those work in this situation, Andy. And if you were here like you used to be, you could be reading it yourself and not being such a piece of S. Okay, so it's okay to boycott other states, but not them. Now, depends on what you're doing. There is a thing called the Dormant Commerce Clause, okay? Because Commerce Clause is going to play a part in this. Now, the Dormant Commerce Clause is you can't, essentially, states can't do something that inhibits the flow of commerce between each state, okay? The Commerce Clause is what the federal government is doing to basically control a lot of stuff, but they also don't want these states to be inhibiting flow of commerce between each other, and that's basically the Dormant Commerce Clause. So, yes, you can do that in a sense, but can states do it? Can states, a function of the government within that state, can they do that? That's maybe where we would have to go a little bit further to figure that out. Okay, maybe we should actually look at the current, or I don't want to do that. There's a lot there. I have all this stuff ready to go, I think, and don't sign me out. Don't sign me out. Okay. Let's take a look here at, this is actually the HR 867 bill. This bill expands an existing anti-boycott law to include certain. Now, I played the McCain thing because he was responsible for the Boycott Act of in 2018. Okay, actually, maybe we should just go there here. And it's interesting because it just says boycott, and it's very open. Foreign countries, IGOs. IGOs, by the way, think of United Nations. Okay, that's a prime one. There's this Arab League. There's a few other ones out there. Governmental organizations that are not U.S. International government organizations that can say, you shouldn't, we're going to sanction Russia because of things it's doing. Now we're going to sanction Israel for things we think it's doing, and the U.S. is like, but how does that affect you? The bill expands an existing anti-boycott law to certain boycotts imposed by international government organizations. Current law prohibits various actions by U.S. persons, individuals, and entities in relation to boycotts imposed by foreign governments on a country which is friendly to the United States, and that it is not itself the object of a U.S. boycott. This bill applies to those prohibitions to similar boycotts imposed by IGOs. Prohibited actions include 1. Refusing to do business with companies organized under the laws of the boycotted country. If the refusal is pursuant to an agreement with or request from the country or IGO imposing the boycott. 2, refusing to employ any person on the basis of race, religion, sex, national origin, and furnishing information about whether someone is associated with charitable or fraternal organizations that support the boycotted country. The bill also requires the president to annually submit to Congress and make available to the public a report describing these boycotts and listing the foreign countries and international organizations involved in fostering or imposing them. Okay, there you go. Now, what is this? This is the original act here, the Israel Anti-Boycott Act, HR 1697, anti-BDS law. I mean, it just comes right out and says anti-BDS law, the one from 2018. I mean, so, you can say it's just all neutral on its face, but it's really not here. That law sounds like it violates the First Amendment too. We will get there, okay? Because we're going to talk about multiple things that possibly trigger, okay? Let's see if I can even have, where was my sheet here? Okay, so here are some issues that you're going to have. We'll walk through them, which I've come up with. The Commerce Clause, which maybe make this viable, okay? And pass muster, okay? Through the Supreme Court. Commerce Clause, there's an issue with that. We'll talk about that. National security and foreign policy, okay? First Amendment considerations, we're going to talk about that. If they determine, as an example, First Amendment would be heightened scrutiny that you're going to have for an analysis, okay? And for due process and whatnot. If you don't get there, if the court determines it's not a First Amendment issue and that it's all based on one of these other issues that we're having, then we don't even get there, okay? So that's one. Narrow scope and government interest. Those are your heightened and intermediate scrutiny things. Precedent from earlier anti-boycott laws and potential vulnerabilities. We will talk about that. Okay. Israel is the law, says Trigger. Yeah. No one is saying you have to do biz with anybody. It depends. That's not necessarily true, I believe. Okay, it is a little bit odd. And I'd have to work through exact situations where that's the case. Let's say you're a country and you don't want to do business with Israel, and the government says, oh, we can impose a fine on you if you don't do that. Because that is not, you can't have those reasons for not doing it. You would have to think of it like this, there's a contract to do business and Israel's there and you're like, nope, we're not going to do it. You may be fined for not participating in the economy in that way. I would think that it would have to be something along the lines of you're trying to get, a city's trying to get a bid for a stadium, okay? And you don't want to, or even when we're in court about being able to strike potential jurors, you have to have for cause or your peremptory challenges, and you can't just say, I don't want a black person, I don't want a Jew on the thing, I don't want to have the black-owned business making my stadium. You may not be able to get away with it in that regard, and I think this is essentially along the same route. Now, the problem you may have are some of these, I don't know if Texas, I think there was that was a little bit different. There was a city there, San Marcos, where they were sending funds to Israel. And they said, we're not doing this anymore. So Greg Abbott's coming in and trying to, shut shit down with that. It's like, okay, whoa, that's sending money over there. I don't know why they're doing that. Are they buying something from them? So the point of this law, and we can, is to respond to the BDS movement. Okay, let's just see what this says here. Was proposed anti-BDS law and amendment to the Export Administration Act of 1979. And so that's what I had referenced earlier, which is basically being able to have foreign trade in a sense, and that was passed in 1979, designed to allow U.S. states to enact laws requiring contractors to sign pledges promising not to boycott any goods from Israel, and their contracts would be terminated, and make it a federal crime punishable by a maximum sentence of 20 years in prison for American citizens to encourage or participate in boycotts against Israel and Israeli settlements in the occupied Palestinian. And this by its own, just written the way it's done here, it seems like an evil law. Okay, but will it pass? Okay, that's part of it. The proposed law was a response to the BDS movement's call for boycotts, divestment, and sanctions against Israel. As of 2020, 32 state legislatures have already passed bills similar to the IABA. If the law was passed in the federal legislature, it would be easier to enforce. Critics of the law and supporters of the BDS claim that it is unconstitutional. They claim that the participation in politically motivated boycott is a form of free speech protected by the First Amendment, and that BDS laws are a form of lawfare. IABA was drafted by Senators Ben Cardin, Rob Portman, and introduced in the Congress in 2018. It had 58 co-sponsors in the Senate, 292 co-sponsors in the House. The act consisted of a House and Senate bill and died in Congress. However, there was strong opposition to BDS in the American politics, and the act is expected to make a resurgence. Okay, so maybe this isn't the exact one. I thought it was, that it was already in place, because that one did have our buddy, you didn't see what I was reading there, did have our buddy John McCain as a tie to it. Let's go here. This is just off of some of the AI stuff here. The Anti-Boycott Act of 2018 was enacted in August 13, 2018 as part of the John S. McCain National Defense Authorization Act for fiscal year 2019. The act aims to discourage and, in some circumstances, prohibit U.S. companies from taking actions that further or support a boycott maintained by a foreign country against a country friendly to the United States. The act is administered and enforced by the Office of Anti-Boycott Compliance, OAC. Within the Bureau of Industry and Security, U.S. companies are required to report to OAC in the receipt of certain boycott-related requests for information designed to verify compliance with an unsanctioned foreign boycott, okay? Unsanctioned foreign boycott. So that's where we're kind of tying in the IGOs. It's not a sanctioned boycott by the U.S., foreign boycott, such as you would have with Cuba, right? We had that. I don't know if there still is, but there's an embargo there for quite some time. Possibly one with a bunch of foreign countries that are on a terrorist list. Also, Russia was perhaps for a while. But if a foreign international government agency like the NATO or whatnot says, "Oh, this is we're actually boycotting this country," okay, now it's an unsanctioned foreign boycott as far as the U.S. sees it. And that would be where the IGO portion is now coming back into it. Prohibited activities under the act include agreements by U.S. companies to refuse to do business with a boycotted company or with blacklisted persons for boycott-related reasons, furnishing information about any person's business relations with a boycotted country, or with blacklisted persons and implementing boycott-related agreements. Violations of the Anti-Boycott Act can result in administration and criminal penalties, including monetary fines and revocation of export licenses. In 2025, the IGO Anti-Boycott Act, HR 867, that's what we're talking about right now, was introduced to amend the Anti-Boycott Act of 2018 to apply its provisions to international government organizations. Okay, so as you can see there, it's probably not going to apply to you as an individual. If you're a company, as an example, from what it looks like to me, and you don't want to participate in buying stuff from Israel, or just don't say anything. Don't come into any agreement where you're going to be putting your name on the line to do so. That would be my recommendation for how you run a business. Just make business decisions behind closed doors. Don't put anything in writing that you just don't want. Just, stay away from maybe doing business with those people. I mean, I don't know. I could be completely wrong on that. I don't understand the full intake of all of this, but there you go. And by the way, when you read this and you just kind of, I think, there's stuff this is kind of coming down and you're like, what? This doesn't forced integration, as screwed up says here. Yeah, you can boycott Qatar, Russia, Iran, North Korea, and Palestine all you want, though. Yes, I totally get what you're saying there. Okay. All right. Now, what I'm going to do here is I'm going to walk my way through a few things, okay? As far as, let's see here. I wanted to let's see if I could find this one. I broke some of these out. I went down a rabbit hole of a few things, and I used Grok on some of it, and then I did follow up on a lot of the other stuff here. Okay, so a U.S. company receives as an example. What's an example of the Anti-Boycott Act of 2018? That you can use. The Anti-Boycott Act 2018. Part of the Export Control Reform Act of 2018 prohibits U.S. persons from complying with unsanctioned. Okay, we talked about that. Here's an example. A U.S. company receives a contract from a Saudi Arabian firm that includes a clause requiring the U.S. company to certify it does not do business with Israeli companies. Okay. Under the Anti-Boycott Act in 2018, the U.S. company is prohibited from agreeing to this clause, as it would support a foreign boycott of Israel. A U.S. ally, additionally, the company must report to boycott requests to the U.S. Department of Commerce Office and Anti-Boycott Compliance, even if it refuses to comply. Failure to report or complying with the boycott could result in penalties, including fines of up to $300,000 per violation and twice the transaction value and potential revocation of export licenses. Okay, so look, that doesn't seem as nefarious. And by the way, nothing in the bill says Israel. Okay, it says foreign country to where we are friendly to. Now, there's probably a list we could go off of there with it, maybe reference over, and Israel would be on the positive list, right? And the other ones, like I said, North Korea might be on the one. By the way, best channel on YouTube. You're welcome. I appreciate that. Trigger warning. Let's give you an applause. Appreciate that. I don't know if it's true at all. By the way, the stream I did on Friday, I started off a little bit under the weather as far as alcohol goes, inebriation. I listened to it back because Jose is like, even in the Tower Gang chat, he's like, oh my God, Tyler's tilted. I read it as titled and I was like, what? Tyler's tilted. He's like, this is crazy. I listened to it back. The best part of having a stream like that is you're like, hey, and I'm listening to it. I'm like, hey, this is interesting. What's going to come next? And you're like, oh, that's a surprise. Interesting that Tyler said that. No, I wasn't that bad. But I must say about halfway through my vocal speed did start to pick up. It was starting to work better. And I think there was some good analysis that still came out of that. However, I'm not there today. So I don't know what this had to do. See, and even with that, you can make, I had a point and then you still lose it because, that was it. That rant was lit. Yeah. Okay. So anyway, that's the idea there. Look, you're going to go a U.S. company. You don't care. You're just trying to do foreign business, and the foreign country has a clause that you won't do stuff with Israel. And, it says you can't agree to that. So, I mean, okay. So there you go. Is that harsh? Perhaps. Just don't fall into the alcoholic lawyer trap. Oh, look. Let's go here and put this on the stream. I'm not at all concerned about. Okay, so it's just not something I have an issue. My wife and I happened to go that day, and this happens every once in a while. And even then, I said I drove home. I didn't. She drove home, and we're just literally a few blocks away from the restaurant. you know, it just, I hadn't eaten much that day. We went there, we were getting drinks. We go to pizza to go. And by the time, then we got the pizza to come home. I hadn't really been eating with that. It just so happened, you know. And by the way, the guy that owns the restaurant, one of the kids there, his son, he's, you know, I don't know, an adult. He kept just filling me up, pouring me more. So shit happened. It's one-off deal. Look, today we're drinking water. Yeah. I mean, I'll do a drink while I do a show. And even then it's not much. At least your kids are old enough to buy their own Coke. Yeah. Yes. It leads to cuckery. My kids are old enough to buy Coke. I certainly hope they do not. My kids are solid. So there you go. Now it's listen to stream for 2 weeks, then talk. I don't know what that's saying. Okay. Let's go into here. So what is the constitutionality of this case? Okay. And then putting the IGOs in place. So I imagine I don't know how the IGOs necessarily get put into here, but it would be a similar situation where they're saying, hey, you're going to adhere to, laws or sanctions. You're not going to do, so it would be something like this. Same Saudi company wants to do business with a U.S. company, and in there might be a clause that says you're not going to do business with anybody that's sanctioned or unsanctioned, or that's on one of these federal international government organizations happens to say is on a list that you can't do business with, and on there is Israel. This would be like So is it as extreme as it's making it sound? I don't know. Okay. I would like to push back on all this and, first of all, and just say, let's go. But here we are. Trigger warning says, is that a warning? I don't know what that's saying. I'm sorry. Nearman Land said that. Trigger warning said, enemies, foreign and domestic, not hiding behind dumb companies. Yeah, by the way, I think if you don't know where I stand on this, I'm not a fan of Israel. I'm also not a fan of Hamas. Okay. I don't know why I have to say that, but that's just where I am. I'm a big fan of the U.S. and I'm a big fan of being able to have U.S. companies do what they want for the most part. But we're going to get into how does Congress even have the ability to do anything with this? Well, let's talk about it. First up, the Commerce Clause. Okay. What did I write on this one? The U.S. Constitution's Commerce Clause, Article 1, Section 8, grants Congress the power to regulate commerce with foreign nations, okay, among the states and foreign nations. Now, the Commerce Clause has been a big problem in general, okay? It's one of those usurped powers, that was never intended to be. And Wickard v. Filburn is the prime extent to what this is a guy, was it Wickard or Filburn? I don't know which one, but he decided to have, so you had these slaughterhouse cases, you had a bunch of these New Deal cases that just started to, take over what basically the federal government can do. And they were centering a lot of it on the Commerce Clause. Okay. Basically like, hey, trade between the states, that's up to us. We're going to do it. Wickard v. Filburn was a guy that grew his own wheat for his own cattle. Okay. He had no intent of selling his wheat anywhere else, but he just did it for his own cattle. Okay. On his own property. They came in and said, you're not participating in, since you're doing this, you're not participating in commerce. And therefore, since you're not participating in commerce, I don't remember what the whole undertaking was, but that's the idea of how they decided that the Commerce Clause affected what he can do with his own animals, his own wheat on his own land. I did an article when I was in law school. It was basically something like wheat in the Constitution. And it talked about the overflow of the taking over the Commerce Clause to this effect. Because that came also into Obamacare, okay? Where they were like, this is commerce between the states. We're able to do whatever we want here and in fact impose a fine on you for not participating in the economy, which is very similar to this one. Now, there's Raich, I believe, or Garcia. I think Raich was one that was out here in California that actually let them, the states, be able to, it kind of broke some of this down. So the Commerce Clause, its effects aren't as noted as they were before. It took a little bit off of Wickard v. Filburn. And that had to do with drugs. It was basically this old lady, I think, wanting to have a roach clip and do some pot. And anyway, you could get into that a little bit more. But the idea is the Commerce Clause. It allows the U.S. Constitution under, the Congress under Article 1, Section 8 to regulate commerce. The Anti-Boycott Act regulates U.S. persons' participation in unsanctioned foreign boycotts like the Arab League's boycott of Israel, which directly impacts international trade and economic relations. Now, this is my writing as to how you would say that they're justified, okay? I'm just going down that route. The courts have consistently upheld Congress's broad authority to regulate foreign commerce, even when such regulations impose restrictions on individual or corporate conduct. For example, in Gibbons v. Ogden in 1824, which I think is still sound law, the Supreme Court affirmed Congress's expansion of power over interstate and foreign commerce, providing a constitutional basis for laws like the Anti-Boycott Act. Now, I'm going to go through and just take a look at that, some key aspects of the Commerce Clause. Interstate commerce, foreign commerce, Indian commerce. Okay, that's the scope of the authority that the U.S. Congress has. Broad interpretation. The Commerce Clause has been interpreted expansively, especially since the 19th century, to give Congress significant regulatory power over economic activities and even non-economic activities with interstate effects. That's essentially that Wickard v. Filburn. Landmark cases like Gibbons v. Ogden define commerce broadly to include navigation and other activities establishing federal supremacy over conflicting state laws. Now, the supremacy clause, that's the idea there, right? If there's two laws, a state law and a federal law that are conflicting, the supremacy goes to the United States, and there's rules. Now, it depends on what it is. A state law can be more restrictive or less restrictive, whichever the favor would be that the federal law would still be binding. Okay, so you can have federal restrictions, as an example, on environmental law, and a state law can conflict with that, but it can be more restrictive, and they're like, there you go. Yeah, that's perfectly fine. You can be more restrictive on a state law even than a federal one because of the type of action that it's actually controlling. Key functions. Federal regulation. This enables Congress to pass laws on issues like trade, transportation, labor, environmental standards, Interstate Commerce Act, Clean Air Act. Preemption. Under the Federal Supremacy Clause, federal laws under the Commerce Clause override conflicting state laws. There you go. Dormant Commerce Clause. We talked about that just a little bit ago. I do have a little bit here. An implied restriction that prohibits states from passing laws that unduly burden or discriminate against interstate commerce, even if Congress has not acted. That's why it's dormant, because there's no action on it. And that's South Dakota v. Wayfair in 2018 had another portion of that one. Okay. Historical and some legal significance on the Commerce Clause. Like I said, Gibbons v. Ogden, that established Congress's power over interstate commerce, navigation. I think that was some boat issue. I think we can look at that one if you want. It preempts state laws affirming the federal authority. McCulloch v. Maryland, I believe this is one of the first cases involving the 14th Amendment, but supported implied powers under the Commerce Clause by creating a national bank to facilitate commerce. New Deal era, the 1930s to 40s, the court expanded the clause's scope, upholding broad federal regulations, the NLRB v. Jones, allowing Congress to regulate labor, agriculture, and whatnot. Modern limits, U.S. v. Lopez. Oh, here you go. Oh, I'd copied these down on a thing, and the court struck down a federal gun law, finding it does not substantially affect interstate commerce. And then Gonzalez v. Raich in 2005 upheld federal regulation of homegrown marijuana, showing continued broad interpretation when activities affect interstate markets. Okay, I think we're done with that part. So the Commerce Clause. Here we go. Ogden. That was a Supreme Court case, 1924, that clarified the scope of Congress's authority under the Commerce Clause. It was in New York, granted Aaron Ogden a monopoly to operate steamboats between New York and New Jersey. Thomas Gibbons operated a competing steamboat license under federal coasting law, challenging Ogden's monopoly. Did New York's monopoly law violate Congress's power to regulate interstate commerce under the Commerce Clause? Decision, a unanimous ruling, Justice John Marshall held that the federal government's power to regulate interstate commerce superseded New York state law. There you go. Okay. The second one. So with that in mind, under Article 1, Section 8, Congress does have the power to regulate international trade, right? Trade between foreign countries and the U.S., U.S. and foreign countries, and between the states. The biggest one we have the impact that's going to impact you the most is interstate commerce, okay? And we've just done, there's way too many things, they all encompassing commerce clause that, the U.S. Has decided they want to just pass laws for whatever reason. I mean, the one with Obamacare is interesting because if you think that, this danger or for whatever reason, throw in commerce, because it doesn't have to be commerce, but that everyone should own a gun under the same pretense that the Obamacare was done. Should you say that everyone should have a gun in their house to protect them? Because if they aren't protected in their own house, at some point, someone can break in, then you're going to go to the hospital. And if you go to the hospital, it's same costs that were associated with Obamacare. You can see how these tricky little things go. Okay, now you've got Commerce Clause is one aspect that they can do this on. The next one is national security and foreign policy. Okay, national security and foreign policy. The act is also grounded in the government's authority to conduct foreign policy and protect national security. The U.S. has long-standing policy of opposing discriminatory boycotts against allies like Israel, viewing them as undermining diplomatic relations and economic stability. The Supreme Court has recognized the government's broad discretion in foreign affairs, as seen in cases like U.S. v. Curtis Wright Export Corp. In 1936, which upheld expansive executive and legislative powers in international relations by prohibiting compliance with unsanctioned boycotts. The act aligns with this authority and as it prevents U.S. entities from undermining U.S. foreign policy objectives. Okay, so the court, you can imagine the court would, if you take this from the SCOTUS's point of view and you're making these arguments, we have precedent also that Congress should be able to say that these are, we just saw this with TikTok. What was the Supreme Court? Because they said it's national security. Some little, twerking bitch out there on TikTok land doesn't understand that China is going to take all her info, and it's a national security issue. And what did the Supreme Court say? Did they say, oh, this is heightened scrutiny? No, they did not. We'll get to that in a little bit. They said, under national security, it's fine. Now, you can disagree that Israel, as we said here, is one, international security interests to have, trade with them. And you could also say that it's a little bit much to say that they're a friendly nation. Okay, there's all, or that they're a big ally. But a government's going to come in and say, we give them weapons, we give them money. You don't give weapons to enemies unless you're Israel giving them to Hamas, right? You don't give weapons and money to enemies unless you're doing that in Yemen and wherever else we've done that, where we're giving it to one side and then we're fueling the other, or Afghanistan. You don't do that, but you do. So the argument is, Your Honor, these are friendly countries. They're on our list. They're on the list here of friendly countries. And they're our strong ally, as Mark Levin would likely say. So therefore, they do have the ability to come in, they being, states or the federal government, Congress, come in and make laws for this. Now, am I I'm going to say this over and over. Am I actually justifying any of this? No. I'm just telling you, these people that are writing this law, sometimes you think they're complete idiots. There's laws in place and sometimes they're upheld. So we'll keep going here. Okay, the U.S. v. Curtis Wright, this is one that was referenced in the Reasons for National Security. A little background, Congress passed a joint resolution authorizing the president to embargo arms sale to countries involved in the Chaco War, Bolivia and Paraguay, okay? Curtis Wright Export Corporation was indicted for violating the embargo by selling arms to Bolivia. Now, this is a little bit kind of the reverse, right? We had an embargo and selling them there, and they're doing it. This is saying you can't not participate with this. You can't outwardly. And by the way, when we were reading that, and it's the situation is like, okay, you can't agree to do these things. Can you just not do them? Yeah. So I would say to those Saudi Arabian countries and whatnot, it's like, look, don't put that clause in here. or these IGOs. Don't put that clause in here, and maybe or maybe not. Maybe I won't sell. Maybe I'm not going to do it. Maybe the money from Saudi Arabia is more important than the money that might come from Israel, right? So the problem with this act, it seems like to me, it's the declaration of what you're planning to do, okay? Putting it in writing. Did Congress unconstitutionally delegate legislative power to the president, and did the president have authority to act in foreign affairs? 7-1 ruling, Justice George Sutherland upheld the embargo and the president's action. The court ruled that the federal government has inherent powers in foreign affairs, distinct from its enumerated powers derived from national sovereignty. The delegation to the president was constitutional because foreign affairs require flexibility, execution discretion, unlike domestic matters. Impact. The decision established the president's broad authority in foreign policy, affirming that the executive has significant latitude in international affairs. Okay, that's fine with this. The more important aspect there, though, is that the foreign security and foreign policy of the U.S. government reigns supreme due to the sovereignty there, okay? The federal government, particularly the president, possesses inherent powers in foreign affairs, and Congress can delegate broad authority to the executive in international matters. Now, we're talking, treaties or, executive orders and those kind of things. No, they're going through Congress at this point, okay? They're going through Congress at this point to enact a law that we're going to see maybe some issues of it. Okay, First Amendment. First Amendment considerations. Okay, with this in mind, we've just seen the first two, the Commerce Clause, being able to act in importance. And once again, we're right in line with TikTok. Did I think TikTok was the ban was a good decision or good law? No, because it was all about trying to protect, Israel in a sense. Okay, now they claimed it was China, but that didn't work. People didn't get worked up about it until it was about Palestine and Israel. And then a little bit of thing about another gentleman on there saying why towers killed Mahmoud Khalil worked for the UN NGOs and not citizen. I think he worked for, was it UK? Maybe it was the UN NGO. Right. He was a citizen. No, he was a green card. He didn't have a citizenship. Okay, let's talk about the First Amendment stuff here, okay? Critics argue the Boycott Act may infringe on the First Amendment rights, particularly free speech and right to engage in political boycotts, as protected by cases like the NAACP v. Claiborne Hardware Company in 1982. We'll look at that case, where SCOTUS upheld boycotts as expressive conduct, okay? The Anti-Boycott Act, however, targets commercial conduct, and we'll get to that too. That's a key aspect. You people are saying, hey, it's this. Okay, is it my conduct? Like as an example, First Amendment, they've determined that certain conduct is expression and is speech, such as burning a flag. Okay, but then is commercial conduct the same? And does commercial conduct, is that an expression? Is that your right? And does it have the same protections? We'll talk about that, okay? For instance, Boycott Act, however, targets commercial conduct, specifically participation in foreign-led boycotts through contractual agreements or refusals to deal, rather than purely expressive speech. So once again, you may be neutral on this issue, but it's someone else that has the issue and they're putting it in their contract and you're agreeing to abide by this contract, okay? That's kind of this third loop that we got here. Courts have distinguished between regulating commercial transactions and restricting political expressions. For example, in International Longshoremen Association v. Allied International 1982, the court upheld restrictions on a union's boycott of Soviet goods, finding that economic actions in support of foreign policy goals were not protected speech when they disrupted commerce. The Act's reporting requirements, mandating U.S. companies to report boycott requests, could raise compelled speech concerns, okay? However, similar requirements have been upheld when they serve a compelling government interest, such as Zadir v. Office of Disciplinary Counsel in 1985, where compelled disclosures in commercial contexts were permissible if, in fact, based and not duly burdensome. So this is your strict scrutiny, intermediate scrutiny, and low level. We'll talk about that in just a tad bit, because certain freedoms, issues that come before the court are subject to different types of scrutiny. First Amendment scrutiny is heightened scrutiny. And heightened scrutiny is the type of, we'll walk through what that actually means. It's difficult for the government to have a law that passes heightened scrutiny, okay? Now, intermediate, yes, that happens. In low level, yeah, those are the ones like pass. It's going to happen. So, once again, does the issue of freedom of First Amendment rights, does it get to that level where heightened scrutiny then has to be taken into account? If it's you talking and it's me talking, it is going to be taken into account. Okay, just so you know that. Okay, let's take a little look here. I think we got one on the First Amendment. Okay, so NAACP v. Claiborne. This is a landmark U.S. Supreme Court case addressing First Amendment protections for political boycotts. It was in 1966, an organized boycott of white-owned businesses to protest racial discrimination and demand civil rights reforms. The boycott included peaceful picketing, but also some instances of intimidation. Got to have that. Local businesses, including Claiborne Hardware Co., sued the NAACP and boycott organizers, claiming the boycott caused economic harm and violated state law. A Mississippi court imposed liability and damages. Did the boycott, including its nonviolent and coercive elements, constitute protective activity under the First Amendment rights to free speech, assembly, and association? The decision is a unanimous one, held by the Supreme Court in 1966 by Justice John Paul Stevens, reversed the state's court's decision. The court held that the nonviolent aspects of the boycott, such as organizing, picketing, and urging participation, were protected forms of political expression, okay, and association under the First Amendment. While isolated acts of violence and intimidation were not protected, those could not justify broad liability for the entire boycott and its organizers. The court emphasized the boycott's political purpose, advancing civil rights, and its alignment with constitutional protections. So the impact of that is the ruling affirmed robust First Amendment protections for peaceful political protests, boycotts, even when they cause economic harm. It strengthened the ability of civil rights groups and others to use boycotts as a tool of social and political change, while clarifying that liability for unlawful acts, violence, must be narrowly targeted to specific individuals, not collective efforts. Yet collective efforts and collective peoples is all we're talking about here. Okay, nonviolent political boycotts, including organization and protected First Amendment forms of free speech and association, but illegal acts like violence or intimidation are not shielded. Okay, that's great, right? So we're like, sweet, and now we're cooking, says trigger warning. I don't know if you're talking to me, but what you have here is, okay, boycotts, First Amendment, heightened scrutiny, even if there's economic impact that's taken place, it doesn't matter. Okay, let's hang on a bit there, right? So, International Longshoremen Association v. Allied International. This is a 1982 case, okay? So it comes after the one that we just had, the Claiborne, which one was it? Claiborne Hardware, okay, in the NAACP. This was a case, 1982 Supreme Court case addressing the legality of a union's politically motivated boycott under federal labor law. This one is much more tied in to what we have here. Background. In response to the Soviet Union invasion of Afghanistan in 1979, the International Longshoremen's Association, ILA, refused to handle cargo shipped from or to the Soviet Union. This boycott affected Allied International, Inc., a U.S. company importing Soviet goods. I don't know, why are you doing that? Causing significant economic losses. Allied sued the ILA, alleging the boycott violated the NLRA, the National Labor Relations Act, as an unlawful secondary boycott. Question, or the issue: did the ILA's politically motivated refusal to handle Soviet cargo constitute an illegal secondary boycott under Section 8B4 of the NLRA? Now, that they're talking about those specifics there, but there's a major point that comes out of this. That's not just so much that you need to know about the NLRA or this law specifically. A unanimous decision, Justice Lewis F. Powell Jr. held that the ILA's boycott violated the NLRA. The court found that the boycott was a secondary action, as it pressured neutral employers like Allied to cease business with the Soviet Union. Soviet entities, rather than addressing a primary labor dispute with the union's own employer. The court rejected the ILA's argument that the boycott's political motivation, protecting Soviet actions, exempted it from the NLRA restrictions, emphasizing that the law prohibit coercive secondary boycotts regardless of the purpose. This isn't the one I was thinking of. This one just kind of ties itself in here. But let's go to key principle here. Under the union-led secondary boycotts, even if politically motivated, are illegal and they coerce neutral employees to alter their relationships. Okay, sorry, I got ahead of myself. Hasbro trolls found Tyler. Okay, is that what's going on here? Am I missing a troll? Okay, the Zordier v. Office of Disciplinary Counsel, 1985. This was the Supreme Court. This is the one I was thinking of. And it's even afterwards. So it's at 85. It's after the 82 case. We coming in here. The U.S. Supreme Court addressing First Amendment protections for commercial speech. Here's what we have. The other one is just a boycott issue. Ohio attorney Philip Zudier placed newspaper ads offering legal services for women injured in Dalkin Shield, an Entrian device. The ads included factual information, an illustration, and contingency fee offered. The office's disciplinary counsel charged Zudier with violating state bar rules, including bans on soliciting clients through ads with illustrations and requiring full disclosure of contingency fee terms. Did Ohio's restrictions on attorney advertising violate the First Amendment's protection of commercial speech? In a 5-3 ruling, Justice Byron White held that parts of Ohio's restriction were unconstitutional. The court reaffirmed that commercial speech, including attorney advertising, is protected under the First Amendment, subject to intermediate scrutiny, the Central Hudson test. The state could not ban truthful, non-deceptive ads or illustrations, and those restrictions did serve a substantial government interest. However, a court upheld the requirement to disclose contingency fee, blah, blah, blah. Impact. The decision strengthened the First Amendment protections for truthful attorney advertising, striking down overly restrictive state regulations. It established that states can require disclosures in commercial key principle, truthful, non-deceptive commercial speech like attorney advertising is protected under the, but states may impose reasonable disclosure requirements to prevent consumers of deception as long as they are not overly restrictive. Okay, so the problem with that one is you want First Amendment strict scrutiny from your free speech, from your First Amendment, and commercial speech is not quite there, okay? The U.S. Supreme Court did not apply strict scrutiny to the attorney advertising regulations at issue. Instead, it analyzed the case under intermediate scrutiny framework established for commercial speech in Central Hudson Gas Electric Corp. And Public Service Commission. Below is a detailed explanation. Context. The case involved Ohio. We know what commercial speech standard. The court recognized the attorney advertising is a form of commercial speech. Under the Central Hudson, restrictions on commercial speech must serve a substantial government interest, directly advance that interest, be no more extensive than necessary to achieve that interest, a proportionality test, not as stringent as strict scrutiny. Strict scrutiny, which we can get to here in a bit. Now, let's look through that. Serve a substantial government interest. We can argue against these things because these are everything's wafflers, right? And if you've ever read of John Hasna, The Myth of the Rule of Law, you'll understand if you go to law school or if you're an attorney. There's two sides that you can always argue here, right? We're seeing this with Karen Reed. We're seeing it with multiple cases. Look at Nick Rekieta as an example, right? There's always two sides arguing to this, and one side may think they're completely right. But you can understand how you can argue both sides, okay? Nothing is just so squared away. Now, there are some things which called strict liability, which is event happens, you're liable. Your dog bites someone, I don't care what the reason, you're liable, okay? Strict scrutiny. Action, liability. That's what it is. But that's not what we're talking about here, okay? So it serves a substantial government interest. Does it serve do you think the U.S. government can make an argument that trade should flow to Israel? Would that serve a substantial interest? Do you think that they can make an argument for that? I think they could. Okay, what is that? I don't know. We give them guns. We give them stuff. We want to have stuff back. There's trade. they're in the Middle East. We want to have access over there. Okay, that's a substantial government interest. Does this directly advance that interest? Yeah, okay. To make sure that your companies aren't boycotting and that we could get stuff over to them. I'm not saying I agree. I'm just saying, can you make this argument? Yes, you can do that. Be no more extensive than necessary to achieve that interest. Okay, I will say this about this act. You know, a lot of people are complaining and, freaking out about it. It's literally, is there an agreement in place that you are going to boycott? Can you just boycott on your own? Do you have to make a statement? Yeah, you can. So it's not overly extensive in that regard. I think it's shit, right? I think there's a reason for this, but can you couch it to formulate around the law? Yeah, you can do that. Okay, so there you go. Strict scrutiny not applied. Strict scrutiny, which requires a compelling government interest and a narrowly tailored means to achieve it, applies to content-based restrictions or fully protected speech, political expressive speech. So now, can you make this argument that I'm doing this for political speech? You can make that argument, but is the court going to say, yeah, but it's commerce? So we've already decided through the Hudson test that we are going down intermediate scrutiny. We're not giving it strict scrutiny. Therefore, good luck with that, okay? Because if it is, it must be a compelling, government interest. We saw that with TikTok. Okay. The Supreme Court held it does not doesn't go through strict scrutiny for that. Okay. Narrow scope and government interest. This is a 0.4 I have here out of 6. The act is narrowly tailored to prohibit compliance with unsanctioned foreign boycotts, not domestic or individual political expression. That is the key. Okay, so let's see. Do we have anything here? I mean, Spud's like, yo, Spud, you're in there. What the fuck? YouTube didn't send me a notification. Sorry about that. You are confusing me. I'm confused. Okay, so just to recap, in case I know Spud Ruckus actually and Jose, they're the two that kind of got me down this thread here. So I want you to understand this is an important part to understand of the law, and I know there's going to be a lot of people out there making their prediction. They could be right, they could be not. Just remember, this law has been in place for a long time. We're just adding NGO, IGOs. International government organizations, okay, Arab League, United Nations, those kind of things. We're just adding them to the list. If you make an agreement with a company that says you can't do X, Y, and Z with a foreign country that's on this list, and we say they're friendly, it says nothing about Israel. We know it's all about Israel. It says nothing specifically about Israel, but that is a specific country, the reason this was drafted. But it could pertain to another one. You could be fined, okay? Is it going to affect you? If you're just you out there doing it and you're not putting anything in writing, as far as like, I'm going to agree to not do business with Israel, you're not going to be screwed up here. Okay. Now, it does not prevent U.S. persons from criticizing Israel or engaging in personal boycotts unrelated to foreign government mandates. It could be a problem with schools, cities, businesses, those kind of things that do have a problem with that. The government's compelling interest in maintaining control over foreign trade policy and preventing discriminatory practices in international commerce supports the Act's restrictions. Courts often defer to the government in such cases, as we've seen in Reagan v. Wald, 1984, which upheld restrictions on travel to Cuba due to foreign policy concerns. Okay, so let's look at that case real quick. 1977, U.S. government under the Trading with the Enemy Act imposed restrictions on travel-related transactions with Cuba, effectively limiting travel there. Ruth Wald and others challenged these restrictions, arguing their violation of the Fifth Amendment right to travel. The regulations were tightened in 1982, prompting further legal action. A lower court ruled the restrictions unconstitutional. Okay, there you go. Did the U.S. government's restrictions on travel to Cuba violate the Fifth Amendment's due process right to international travel? Now, as you know here, maybe you don't, Fifth Amendment should have only applied to the federal government, not to the states. This is an application of the Fifth Amendment, okay? Not this 14th Amendment roundabout way. You're talking about, can the U.S. government stop you from doing this, okay? So we've got an actual application of the Fifth Amendment, which is correct. Decision 5-4, Justin William Rehnquist. upheld. Now, this is a close one. We've seen a bunch of these ones that are ruled, 7-0, 7-2, 9-0, unanimous. A bunch of them are unanimous on some of these issues. This one's not. The court recognized the limited right to international travel, but held that it is subject to reasonable government regulation, especially in foreign policy matters. The restrictions were justified by national security and foreign policy concerns, including Cuba's ties to the Soviet Union and its designation as a hostile nation. I mean, it is funny here, and I said this to Jose earlier, which is, I mean, one, you're restricting. You're saying, look, we're just restricting you from doing X, Y, and Z. Okay, that's fine. This one, they're saying you must do X, Y, and Z. Now, they are couching it in the right way, which is you can't make an agreement to not do something. So it's still a little bit coercive feeling, okay? But I don't know that technically it gets to that position. The restrictions were justified. We said that the court deferred to the executive's broad authority in foreign affairs, finding the regulation did not unduly infringe on constitutional rights. Now, a lot of these arguments you're seeing here, it will be interesting to see how they all play out if they come to the Supreme Court, if they're going to be somewhat similarly consistent with Trump's immigration policy, okay? I haven't gone down that route, but you could see a lot of play here, right? Supremacy clause, the executive, Congress, the federal government has a lot of power to do X, Y, and Z, what's been enumerated in the Constitution for them to do. And then, judges are saying, no, no, no. Now, we'll see how it all works out. Impact, the decision from the government's authority to restrict travel to specific countries. So this is a Fifth Amendment right. So international travel is not absolute and can be restricted by reasonable government regulations. So point is on this one that, narrow scope and interest, it's tailored that way. We will see what happens. This is just one more aspect and, some precedent to do. Now, this is the last one here, which is precedent. No, I have two more. Precedent from earlier anti-boycotts. Now, the Anti-Boycott Act of 2018, which we've talked about, builds on earlier regulations of the Export Administration Act in 1979, which also prohibits compliance with foreign boycotts. These regulations withstood legal challenges. For example, in Briggs v. Stratton Briggs and Stratton v. Baldridge, 1984, a federal appeals court upheld anti-boycott regulations, finding that they did not violate First Amendment rights because they regulated commercial conduct with incidental effects on speech, and the government had substantial interest in opposing those boycotts. So let's look at Briggs v. Stratton, 1984. It was a U.S. Court of Appeals for the Seventh Circuit addressing the constitutionality restrictions under the Export Act. As we said, Briggs and Stratton, a manufacturer of internal combustion engines, and its Vice President Michael Hamilton received questionnaires from Arab boycott offices as part of the Arab trade boycott of Israel. Directly on point, okay? And Commerce Department regulations prohibited U.S. companies from responding to such questionnaires to avoid supporting foreign boycotts conflicting with U.S. policy. Briggs and Stratton, fearing backlisting from Arab states, challenged these restrictions, arguing they violated the First, Fifth, and Ninth Amendments rights. Did the EAA's prohibition on responding to Arab boycott questionnaires unconstitutionally infringe in the plaintiff's free speech, due process, or other constitutional rights? In a ruling by Judge Eschbach, the Seventh Circuit affirmed the district court's summary judgment for the government. Okay, the court held, this one didn't even go to the Supreme Court, held the UAA's restriction did not violate the First Amendment. I wonder if they applied for certiorari for the Supreme Court and it just was denied because they're kind of like, out of here. Did not violate the First Amendment as responding to boycott questionnaires constituted commercial speech with limited protection. We just talked about that. We just went over it with the Hudson test on commercial speech, which is intermediate scrutiny, okay? The government's interest in regulating foreign commerce and preventing U.S. companies from supporting boycotts contrary to U.S. foreign policy justified the restriction. The court also rejected Fifth Amendment due process claims, finding the regulations rational and an unconstitutional taking of property, and dismissed Ninth Amendment arguments as meritless. There you go. The impact, the decision upheld the government's authority to regulate commercial activities in foreign affairs, even when they involve expressive elements, reinforcing the EAA's anti-boycott provisions. It clarified the commercial speech, and in this context is subject to regulation when it conflicts with national foreign policy interests. The government can restrict commercial speech, such as responses to foreign boycott questionnaires under the Export Administration Act, without violating the First Amendment, provided the restrictions serve a substantial government interest in foreign policy. There you go. I have no idea what you're yabbering about. I'm discussing the topic. Okay, it looks like there's fighting going on. I love it. Sorry about the chat stuff here. This is what Spud said. It just angers me how there is constant chipping away at protection of freedom to resist boycott, criticize Israel, especially when they're using third-party foreign institutions and their definitions. You're not getting any argument from me on that, Spud. Absolutely. The IHRA, the International Holocaust Remembrance Alliance, is not it's not a definite. Matter of fact, when they reference anti-Semitism in Congress, they reference the working definition of the IHRA for anti-Semitism. That comes from somewhere else, okay? It's not even an American definition. And it's a working definition, which means we change it as we feel free to, okay? So yes, they're chipping away completely at that. I'm just, I wanted to dispel this isn't as extreme as a lot. Now, you know, if I was a company doing imports, exports, as George Costanza was, Vandelay, and I'm doing it with foreign countries, I may be worried, right? I'm going to get a whole compliance department just to go through this. And then maybe when it's with a Saudi company or an NGO or IGO that comes here, they put that list, you're just going to go back and say, look, your money is important to me. I don't know that I care to do business with it. I'm not going to restrict myself from doing it. And then personally, as a business, I would be doing that as well. I don't know. Look, I follow, and I've talked about this a bit. I used to be a professional cyclist. I followed it. I follow all this stuff. There's a few interesting aspects of cycling which kind of tie into this, right? And there is an article which I was possibly going to read. Not today, but we'll do it for another time. There's a cycling team called Israel Cycling Academy. It's out of Israel, okay? Now they're called Israel Premier Tech. Anyway, cycling is like NASCAR, where your sponsors just come from whoever you can get for a team. But then we have Bahrain, they sponsor a team. UAE, United Arab Emirates, they sponsor a team, okay? Katusha used to sponsor it. So you get these weird aspects. And then some people are like, I don't want because of these human rights violations. I don't want it because of these human rights violations. So it's very interesting, right? I'm a little bit more along the lines of, what's a good price? Who's making it? I mean, I have an iPhone, a small Chinese girl is making that. Am I going to really be this particular and this specific? I'm going to, so the point I'm getting at, if I had a business, would I be taking a stance necessarily on who and what another business that I'm contracting with is going to tell me where the fuck to buy something? No. If there's only one part that I can get and it happens to be from Israel, I'm probably going to get it from there, okay? Last thing we'll do here is potential vulnerabilities for this act, which I do want to go over, which we've been talking about this whole time as well. Texas v. Johnson, 1989 landmark U.S. Supreme Court case addressing the First Amendment's protection of flag burning as a form of political expression. I mentioned that. Oh my God, Tyler, did Paul DM you about going on their show yet? Let's take a look. I doubt it. Let's go to X. I'm not on X all the time. I've got 4 different messages. Spud said something. Okay, because she sent me something. That club, I can't name that group. Nope, didn't do it. Sorry, buddy. They did not DM me. Those are bastards. During 1984 Republican National Convention in Dallas, Gregory Lee Johnson burned an American flag as part of a protest against Reagan administration policies. Excuse me. He was convicted under Texas law prohibiting flag desecration, fined, and sentenced to 1 year in prison. Johnson appealed, arguing the law violated his First Amendment right to free speech. So you guys can probably already figure out where this is going, because we've talked about it, and what you probably just know in general, which is, can you burn a flag? Now, can you see that? I have a flag behind me. Okay. And it's a little blurry because where my camera is. That is my grandfather served in World War I. Okay, and then he was born in 1890 something. I wrote an article. If you go to my Substack, which you guys should all do, go sub to my Substack. I'll put it in the link here, and I post all the podcasts there. Okay, usually on that one I put all the links, but I have some articles and stuff. I went there. I would like to get a members page, and we can just do that with the Substack. You could apply for free. I have one paying member, and it's my friend Matt, my high school friend. I'm like, why did you do that? But thank you. But I put all the shows there, but I did an article there, and it's about my grandpa. He served in World War I. He had religious convictions that he didn't want a certain day of the week. We're not Jewish, but point is, he gets court-martialed for this. He had permission to do so. He gets court-martialed. He got sentenced to 15 years, I think 15 years in Leavenworth prison, federal prison. He only ended up spending 6 years from there. Went on, had 5 kids, whatnot. President Ronald Reagan, which when you think about this is appropriate too, which was 1989. Well, it was at the Republican convention. It was after Reagan. Oh, it was Reagan protested. He's protesting the Reagan administration, though. That's where I knew the name came in. Ronald Reagan actually pardoned him and gave him out. So he was able to have his flag when he died. And I have a thing here, and I have some articles about his life. Never anti-American. He had every right to be, because he did not get any of his benefits. Okay. At the time when Reagan's in there, this dude's almost 100 years old, and he didn't get any of his war benefits, veteran benefits, none of that. And he had every right to hate his country for the way that they treated him, and he didn't. It's an interesting story. Okay, I still pay on locals. Okay, JC, I'm gonna stop that. Oh wait, locals? You're paying on locals? Do I put anything on locals? I need to get this consolidated. Locals, I have Odyssey. I think I'm going to work this out. I think I'm going to figure this out, because I would like a place. Maybe JC, you DM me. What do you think is the best place, you guys, to have a group here? There's Telegram, that could be. But I would like to do some private shows as well, and perhaps we'll have to. I guess we can do that on locals. Maybe I need to get this shit figured out. We'll work on it. JC, maybe I owe you a big meal or something. Anyway, so the decision came down. William Brennan held that Johnson's flag burning was protected speech. Okay, the court found that the burning the flag was expressive conduct, conveying a political message, and thus there was strict scrutiny. That's exactly what we're talking about here. However, the problem with that, as we've said, is you've got this issue of commercial. So if you can at all get the Supreme Court to say that this is it's not commercial speech, right? That it just happens to be kind of what you want, then maybe you have a chance there, okay? And I think you have more of a chance on this, that it could be considered political speech rather than commercial speech, because you're doing it in a commercial way, but you're trying to make a political. I think it's tough the way the precedent has already been set here. So we'll just go through real quick here. Definition of strict scrutiny: it's got to be a compelling government interest, must demonstrate that the law or action serves a compelling vital interest, and more convenient or preference is insufficient. Okay, and that's the one that makes it very difficult for the government to have a law passed compelling that. Now, it must be also narrowly tailored. The law or action must be precisely crafted to achieve the compelling interest. Okay, once again, and less restrictive means the government must show that there is no less restrictive alternative that could be effectively to achieve that goal. So that's strict scrutiny. That would get us there to make this unconstitutional, but you're likely not going to get there. So when people are out there and they're arguing, this is unconstitutional, just remember, okay, or it's against the First Amendment. Is it? Maybe it's not. Maybe you'll be that little smarter person. You can have that autistic response on Twitter and say, however, under, which one was it? Which one? Let's go back and see if I can remember which case was, it was commercial speech, Zuperter or something like that. Yeah, Zoderer v. Office of Disciplinary Counsel. Okay, that one was determined that it was not. Okay, so you can be that person pushing back on Twitter saying, hey, there's commercial speech which doesn't have the same protections as just your First Amendment rights as me as an individual. If they're coming after me as an individual, you bet I'm going to be able to assert this and then probably be it. Okay, Read the Claiborne decision. You almost did. Yeah, Claiborne was one of we as well. Strict scrutiny applies fundamental rights explicitly or implicitly protected by the Constitution, such as free speech, free expression of religion, voting rights, the right to travel. Example, Texas v. Johnson, we just talked about that for flag burning. Those are going to get your fundamental rights. Those are going to get heightened scrutiny. You got to get over that commercial one. Suspected, and then you have, certain types of classes, content restrictions or speech. This is one where you might be able to get there. Let's look at the suspect classes. Laws or actions that discriminate based on protected characteristics like race, ethnicity, national origin, or under equal protection clause. I mean, that might be a problem for you saying, I don't want to deal with these people because of their race. Now you've got a problem, and that doesn't necessarily mean that law is going to be, disallowed. Content-based restrictions on speech. Laws that regulate speech based on its own message or viewpoint as opposed to content-neutral regulations. I mean, if you're just saying, look, you're coming after me and this is a content-based restriction because I can't protest against the Israel and for what they're doing over there, then it's content-based and maybe you're going to get the heightened scrutiny. I don't know. It's going to be a problem. Okay. Either locals or Substack. I kind of lean towards Substack. I think that's so too. Something about locals. The only problem I have right now is I could use OBS and I could do a show directly to locals where it's not a problem. I don't know if I could do a live one for only for the fans on there. Okay. I think we're almost done with all of this. I think I've walked through conclusion. Anti-Boycott Act of 2018 is constitutional under the Commerce Clause. That governs foreign policy authority, and it regulates commercial conduct in its international trade to protect national interests. While the First Amendment challenges could arise, the Act's narrow focus on unsanctioned foreign boycotts and its alignment with precedents like Briggs and Stratton, international longshore. Yeah, Briggs and Stratton actually was the big one to look at. That's the most recent. It's a little bit more on point. And especially with the analysis of the commercial speech. Longshoremen suggest it withstand scrutiny. Courts have historically deferred to Congress in regulating foreign commerce, national security, and making an act as permissible exercise of federal power. There you go. Okay, guys. Substack. I do have a Substack. Let me see. Maybe I'll pull it up here and you guys can just take a look here. Let's see what we have. Let's go to, we don't need to see. The problem is it's showing me my view. I want to see Tyler's, what you guys would view. Here we go. There we go. There's my Substack. It's got, I don't know why it looks weird like this, but there's a whole Leo Frank ADL. I guess it's kind of pinned on the front there. That was a big one that had, I have some of these articles over here. Look at this. Mean Tweets. It's about Megyn Kelly. That's perfectly fine. The Respondent book review. Andy and I had gone through that. Family Law in a Libertarian World. Check that one out. Anti-war libertarians and the left. Belated Veterans Day to my grandpa. This was the post I did here. Here he is, Leslie and Rose Yonke. He got his general discharge. And look at that. This is our flag. Be proud of it. This was in 1983 that they got this pardon. And that was pretty cool. I'm going to post this on our link here. I did a video also where I just read it. But I think if you want to read this, a little bit about kind of that backstory, I think it's pretty good. And, kudos. Grandpa's dead, of course, but there you go. Thanks everybody for coming in. I don't know if you have any other questions about this. Put them in my DMs. We can do a follow-up on this. By any no means am I... do we still have... There we go. By no means do I support this law, okay? By no means do I support this law. But is it going to be... is it going to pass? And now you have a little bit of ammo out there, right? And I'm not saying you need ammo. It's what bothers me. And I saw this because we could go to tweets about this. I think I have some tweets. Maybe we should just look at these real quick and then we will be donezo. We talked about what an IGO is. I think everyone understands that. X posts. Oh, no, that's not the one I wanted. I wanted this one. So this is... This is the Mises Caucus. You know, this person puts this up, Congress to ban boycotting Israel. Well, did they, we went through this. Are they boycotting, they're banning boycotting Israel? Not really. I mean, you got to be a little bit more precise, right? It just bothers me. It proposes fines up to $1 million, up to 20 years in prisons for Americans participating in boycotts of Israel or its settlements. Not necessarily. And then direct violation of the First Amendment. Now, I would wish it was that's the case, but as read and with case law and precedent, is that actually the case? Okay, now you can push back to the Mises Caucus, which they've had some horrible legal takes throughout the years. I've done shows on it because they're so. I love the Mises Caucus, but they're also a bunch of dumb fucks that I don't know who the legal person is that posts this kind of stuff. I'm not saying this one is bad, but they have done really bad stuff. So as soon as I saw this, that's why I immediately like, maybe legally I should take a look at it, and I'm glad I did. The contracts say Israel or persons of Jewish origin, you support that. Where does it say that? Let's go. Maybe we're not done. Let's take a look here. Okay. This is the actual act that's going to be Israel. There you go. Zero results. It's not showing this. Here you go. So here's the actual act. I think this is the one that was put in, in 2018. That's the one. So here's the word Israel. It finds 0 mentions of Israel in this act. So it says foreign country, and it's just going to take foreign country, and it's going to add IGOs to the end of it. Okay. So what am I missing? Am I missing something there? Is that what it is? There's the one chat that's at least working a little bit. Saudi contracts often say that. Yeah. Okay. That's what we just talked about. Yes, I understand. Saudi contract is going to say that. Saudi contract is going to say that, and this makes it illegal to to sign on that you're going to. Then don't sign a contract. Am I okay with it? I'm not okay with it. And if anybody comes back and says, "Oh, this guy's supporting this law," I'm just breaking down how I think, how our structure is, how the law is, how precedent and whatnot, and how this law is specifically designed. Is it going to pass? Is it going to be found to be constitutional? I believe is going to be found to be constitutional. Do I like that? No, I don't like it. There's a lot of laws that I don't like. A lot, and some things about the Constitution I'm not a fan of either. Okay, so if anybody out there says, "Oh, this guy's supporting it," no, I'm giving you a breakdown of why I think this, and is it as bad as they're making it sound? I don't think so as well. Matter of fact, what we just looked at, the guy's like, it's you as a person aren't getting. It's not going to happen. Okay. What does the Saudi law say, though? I don't care what the Saudi law says. I don't know if it's to me, but anyway, I think we're done here. I appreciate everybody coming in. Sorry I wasn't able to check out all the chat, but I think we got to a lot of the law. I hope you enjoyed this breakdown. Once again, like, subscribe, share this show out. Go to our Substack, tyleryanke.substack.com. Is that what it is? tyleryanke.substack.com. There you go. TYLERJANKE. My name right there. .substack.com. Just sign up for free. Be there, and we can start having communications there as well. Have a good weekend. I'm gonna go. I think I'm gonna barbecue at my sister-in-law's house. Till next time. Love y'all. Bye.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you! You started writing your opinions.
And it just makes me wonder, you're dead, bitch. Why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.